Hi, it's me, Brodie McLeod, with another my probably going to be underwatched, underappreciated, undervalued, and pretty much obsolete YouTube videos that don't serve anything but my own nefarious ends to probably somewhat narcissistically, or in the essence of Narcissus and his mirror, just feel like I'm doing something or trying to raise awareness about a problem. I've got family members who've been raped literally thousands of times in psychiatric hospitals, in domestic buildings, in secret military sort of areas, where obviously they can't contest who was there and what was there because it we were protected by the National Official Secrets Act. It's really fucked up. And I kind of threatened a load of people, right? I was like, look, if you're going to keep on torturing and raping my innocent children and nieces who've done nothing, then what I'm going to do is turn the tables and put it on you that if you don't turn yourself in, then I'm going to come for your innocent family. Basically, it was a tragedy. Loads of people just topped themselves and killed their children. It was really dark, and now I'm completely fucked. But hopefully, we'll be able to work out a way to resolve it. But it was just a disaster. You know, kind of bloody-minded mental illness affected me quite a lot, and it's not really anything I can use as an excuse. You know, it's like it is the reason why I started threatening people. Loads of people, I mean, literally this threat apportioned sort of accountability and liability to literally thousands of people over the last 30 years who've abused my siblings and also murdered my parents and stole all our money. Not that we had any access to it in the first place, but it was an awful lot, much more than you might imagine. Anyway, if you don't want to watch or listen to subjects relating to child abuse or rape or self-defense, then do make sure you hit the pause button now and watch something else, maybe some Disney movies or, like, I don't know, Teletubbies, whatever's good for you, yeah. But I had to use Grok today. Got a lovely shiner, by the way, look at this. It's starting to go yellow. I had a bit of an altercation with somebody on the ward the other day. Gemini didn't like the prompt, so I'm using Grok. My prompt was, if hypothetically a person walks into a room and witnesses a family member, potentially a young child, being raped, in which nations would it be lawful/legal to shoot to kill, assuming that the witness was armed? Explain like a Guardian journalist why this might not be legal in the UK, primarily as a country with extremely strict gun ownership laws, but explore the legality or lenience which might be applied by the UK legal system, which is similar in principle to the French legal system's crime of passion dispensation. Conclude that many people are pathologized into mistreatment and abuse, but there's also many who simply don't give a fuck and don't particularly have a penchant for children, but simply operate in networks where gang rape is frequent and normalized amongst certain demographics of society. For example, would it be acceptable for a mother or father to kill a man using a hammer upon walking into a room finding someone raping their child? In the UK, that is. You know, don't use any charts or graphs, simply explain explicitly how the law differs in the UK, as well as how it mirrors legislation and laws surrounding extreme provocation and immediate danger in the UK versus other nations where self-defense is more preeminently legislated for. So a response I got from Grok, which is what I'm reading today. You can have me in the little circle at the top. Can I do that on this? And that's not working. There you go. In many jurisdictions with robust stand your ground or broad defence of others doctrines, most notably large parts of the United States, lethal force would be lawful in the exact scenario you describe. A parent or guardian who reasonably believes a child is imminently facing rape, a forcible felony involving great bodily harm or sexual violation, may use deadly force without retreating, provided the belief is genuine and the response is proportionate to the threat. States such as Florida, Texas, Oklahoma, New York for forcible rape and dozens of other codify this explicitly. Self-defense or defense of another justifies homicide if it stops imminent death, serious injury, kidnapping or sexual assault. Castle doctrine often extends inside a home with a presumption resides. I want to start that sentence again, I've just woken up. Castle doctrine often extends this inside a home with a presumption of reasonableness. Similar principles appear in places like the Czech Republic or certain Swiss cantons, where self-defense against violent felonies carry a wide latitude. These systems treat the protection of the vulnerable, especially a child, as paramount and preemptively legitimate, viewing the Assailants Act as creating an immediate justification for lethal intervention. In the United Kingdom, by contrast, the same act, particularly shooting to kill, would almost certainly not be straightforwardly lawful, and the hypothetical armed witnesses would face profound legal peril from the outset. Britain operates under some of the world's strictest firearms control. Civilian gun ownership is tightly licensed, almost never granted for self-defense, and possession of a handgun or shotgun without lawful reason is itself a serious criminal offence under the Firearms Act 1968. Even if we imagine the witness somehow had legal access to a firearm, like a vanishing rare scenario, using it lethally would trigger intense security under Section 76 of the Criminal Justice and Immigration Act 2008 and common law self-defense principles. The law permits reasonable and proportionate force to defend oneself or another from imminent unlawful violence, including rape. You do not have to wait to be struck first, and there is no duty to retreat. Courts assess what a person does honestly believed in the heat of the moment, allowing for instinctive reactions. Yet reasonableness is judged objectively by a jury. Well, it used to be anyway. I think they've done away with that now. Weighing the level threat against the response. Rape is undoubtedly a grave offence causing serious harm. So some force, including potentially lethal force if no lesser option exists, could be defended. However, shooting an assailant who is not armed with a firearm, or where the rape could be arguably stopped by lesser means, a tackle, a blow, or by calling for help, risks being deemed disproportionate. Post-incident investigations by the Crown Prosecution Service and coroner inquests routinely examine whether the shooter overreacted or continued force after the immediate danger passed. The result is often a manslaughter charge at minimum, or murder if intent to kill is inferred. With self-defense argued at the trial, Britain's legal culture, shaped by centuries of policing and consent, low gun crime and a parliamentary emphasis on de-escalation, prioritises the sanctity of life and the state's monopoly on lethal force. Vigilantism, even in extremists, sits uneasily with a legal system that trusts due process and professional intervention over armed citizens. This does not mean the UK system is wholly inflexible or offers no lenience, akin to the old French crime of passion, criminal passionnel. Until 1975, French law explicitly excused a husband who killed his wife and a lover caught in a flagrant delicto. It was a partial defence rooted in honour and sudden emotional overwhelm. So Britain never had an identical statutory carve-out, but it once recognised a common law provocation defence that could reduce murder to manslaughter where the defendant lost self-control in response to grave provocation. That was abolished in 2009 by the Coroners and Justice Act and replaced with the partial defence of loss of control under Section 54 and Section 56. A defendant who kills after losing self-control because of a qualifying trigger, fear of serious violence or circumstances of an extremely grave nature, may be convicted only of manslaughter if a reasonable person of the same age and sex, sharing the defendant's characteristics, might have reacted similarly. Courts have accepted that discovering a child having been raped could constitute such a trigger. The terror and rage are humanely understandable. Juries are directed to consider that the heat of the moment does not demand perfect proportionality from a parent in panic. Self-defence itself remains a complete defence, so full acquittal. If the force was reasonable in practice, prosecutors and judges have shown pragmatism in genuine cases of parents or bystanders protecting children. The law explicitly allows preemptive action against an ongoing attack and recognises that people under extreme stress do not calculate force with clinical precision. A parent walking in on their child being raped would have a strong argument that any immediate force, striking, restraining, even using an improvised weapon, was necessary to prevent the crime. The system is not blind to human frailty, it simply channels that recognition through structured legal tests rather than a blanket passion exemption. So take the hammer example you pose, a mother or father discovering a man raping their child and killing them with the nearest heavy object. Under UK law, this would very likely be treated as lawful self-defence or defence of another, provided the force was used while the assault was ongoing and the parent genuinely believed it was necessary to stop it. The hammer is not a premeditated firearm but an object of opportunity. Courts have repeatedly upheld their use of household items as genuine emergencies. Prosecution would have to have proved beyond reasonable doubt that the response was grossly disproportionate or continued after the threat ended. So juries drawn from ordinary people are not robots. They understand parental instincts. Successful acquittals or manslaughter outcomes in analogous heat of the moment cases illustrate that the law, whilst strict on paper, retains space for compassion when the facts align with immediate proportionate protection of the vulnerable. Deeper tragedy is that while some individuals who commit such horrors are genuinely pathologised, driven by trauma, mental illness or compulsion that the system roughly tries to treat, many others simply do not care. They operate within subcultures or networks where predatory sexual violence, including gang rape of children, has become normalised and even ritualised, detached from any psychiatric excuse. These are not always lone deviants or participants in social circles that treat such acts as status, bonding or entitlement. Britain's legal response, emphasising rehabilitation, proportionality and state oversight, can feel inadequate precisely because it assumed most offenders are redeemable or disordered. When the evidence from organised grooming scandals and persistent group offending shows that for some cohorts the behaviour is cultural and collective rather than purely individual pathology. The law's restraint, born of gun control and anti-vigilante principles, reflects a society that has chosen collectively safety and due process over armed self-help. Whether that choice adequately deters the coldly indifferent remains an open and painful question.